Great. Welcome everyone to today's program on Trust, Reformation and Decanting. I'm Dina Nam, one of the co-chairs of the Beverly Hills Bar Association Trust and Estates section. Before we begin, I wanted to make a few housekeeping announcements. You will receive your MCLE certificate shortly after the program, and your certificate will also be stored in BHBA Plus, our members-only community. So please take a moment to complete the survey that is included with your certificate. This program will also be available in a few days in BHBA On Demand, BHBA's newest member benefit presented by Lawyers Mutual Insurance Company. I also wanted to make a few announcements on upcoming programming in March. On March 21st, we do have our time with the probate judges, and registration details should have been emailed out. So that should be a great program with all the probate judges in our courts. Secondly, we also have on March 30th from 6 p.m. to 8 p.m. our first in-person Beverly Hills Bar Association Trust and Estates Mixer. Email or registration details should have also gone out for that event, but details will also be in the chat if you have not had a chance to register for that program. Now I'd like to introduce Bryan Joy of the Sanborn team for a few words.
Thank you, Dina. Good afternoon, everyone. As a proud sponsor of the Beverly Hills Bar Association for the past 17 years, we are always honored and humbled when we get a referral from this very esteemed group. At the Sanborn team, we are specialized in representing administrators, professional fiduciaries, and conservators in the sale of real property. Our perfect referral comes from trust, probate, and estate attorneys just like yourselves. All we ask is that we're one of the people that you give out when someone asks to sell real estate. Just as a quick market update, we're still getting multiple offers on most of our listings, and most are coming in over asking. The key is pricing at the very beginning. It's very important. Another item of note is that we're getting less offers overall. Our most recent properties with multiple offers have received 2 to 4 offers. However, we're still selling with no buyer contingencies. Thank you for your time and most importantly, your referrals. Enjoy the meeting.
Thanks, Bryan. Next, I'd like to introduce Orit Gadish of Geffen Real Estate.
Thanks, Dina. Hi, everyone. I'm Orit Gadish, broker and owner of Geffen Real Estate, specializing in representing trustees, executors, and administrators. When you work with me, you don't need to worry about having funds to pay to get a property ready to be placed on the market, whether it's just a trash out, cleaning, replacing a broken window, or repairing a broken gas valve, or getting a cousin or the caretaker that never left to move out. Or if the beneficiaries would like a complete remodel to maximize the return on the sale for the estate or trust. We do whatever is right to get the highest return on a real estate sale for your clients. I'm happy to help you with any of your real estate needs, residential or commercial, as is or renovated sales strategies with no cost upfront to the estate or trust. Also, if you'd like to connect with me on Zoom or get together for coffee or lunch, please reach out to me. My contact info is in the chat box. Enjoy your program, and back to you, Dina.
Thanks, Orit. In addition to the Sanborn team and Geffen Real Estate, the Trust and Estates section is also sponsored by Glen Oaks Escrow. Marcine Klein is a full-service escrow officer specializing in probate, trust sales, conservatorship, and both court and independent administration of Estate Act transactions. On a daily basis, Marcine works to ensure that even the most challenging escrows close smoothly and that her clients are beyond happy with their experience at Glen Oaks Escrow. Next, California Title Company provides comprehensive and timely title insurance protection for homebuyers, including first-time homebuyers, sellers, veterans, and military personnel, seniors, real estate agents and brokers, mortgage lenders, and commercial real estate professionals. Now onto the program. Next, Jennifer McNeil-Lozano will provide us with our legal updates.
Thanks, Dina. First case we have is the estate of Franco Moreno versus Bertuccio, Court of Appeal case number A165840, First District, Division 3, filed January 30th, 2023. In this case, Bertuccio was issued letters of administration for his biological father, Franco's estate. Franco's sister and niece, the Morenos, both filed petitions to remove Bertuccio, and along with a joint motion for summary judgment, seeking a declaration that Bertuccio is not an heir entitled to inherit from Franco's estate under intestate succession. Marilyn and Frank Sr. were married at the time of Bertuccio's conception and birth. Frank Sr. was named as Bertuccio's father on his birth certificate and paid child support after his divorce. As an adult, Bertuccio discovered that Franco was his biological father. Bertuccio and Franco connected and forged a relationship, and Franco told his girlfriend and neighbor that Bertuccio was his son. Franco died intestate, where the entire estate would pass to his issue, Bertuccio, if determined an issue, or the next of kin, the Morenos. The probate court granted Moreno's motion for summary judgment, holding that Bertuccio was a child of the marriage of Marilyn and Frank Sr. under Family Code Section 7540, the marital presumption, and that consistent with Cornelius, Bertuccio would then be barred from proving Franco as his natural parent from whom he would inherit. Bertuccio appealed. 6453B2 would provide Bertuccio an opportunity to establish paternity with clear and convincing evidence that Franco openly held him out as his child. However, 7540 provides that the child of spouses who cohabitated at the time of conception and birth is conclusively presumed to be a child of the marriage. A child of the marriage under 7540's marital presumption is barred from proving a parent-child relationship existed for purposes of inheritance under intestate succession. So although the marital presumption as a matter of public policy promotes the integrity of family and the stability of inheritance, here the court erred in applying the marital presumption without first making the finding that Marilyn and Frank Sr. were cohabitating at the time of Bertuccio's conception and birth. So the appellate court reversed and remanded for further proceedings. Then we have Starr versus Ashbrook, Court of Appeal case number G060597, 4th District, Division 3, filed January 3rd, 2023. In this case, Jonathan Starr filed a petition challenging M. Thomas Ashbrook actions as the acting trustee of his father, Arnold Starr's revocable trust. The petition alleged that Ashbrook had wasted and misused trust assets by pursuing a meritless petition for instructions and using trust assets to fund an elder abuse litigation against Jonathan and his brothers. He alleged 4 causes of action: 1, to suspend the trustee, to enjoin the trustee from further breach of trust, to remove the trustee, and to surcharge the trustee for the breach of trust. Soon after filing, Ashbrook resigned as trustee, and the only remaining action was the surcharge claim. Jonathan requested that the court surcharge Ashbrook for all trust monies expended and dissipated since becoming trustee, including all legal fees expended in the litigation and the funding of the elder lawsuit. Ashbrook responded by filing a special motion to strike the surcharge cause of action pursuant to California's anti-SLAPP statute. The court concluded that the surcharge cause of action was based on allegations that Ashbrook, as trustee, spent trust money in a manner that did not benefit the trust and wasted trust assets without authority. And even if it arose out of a protected activity, Jonathan Starr had submitted admissible evidence to meet his burden of showing potential liability for breach of duties of care and loyalty. Therefore, the court denied the anti-SLAPP motion and Ashbrook appealed. The core issue is whether, as Ashbrook asserts, the surcharge cause of action arises from allegations of pursuing and funding litigation, which are constitutionally protected activities under 425-16b1, or, as Jonathan Starr asserts, from allegations of waste and misuse of trust assets, which are not protected activities. And the appellate court analyzed analogous opinions in Greco, Gaynor, and Manlin, where the court acknowledged the protected activity of litigation, but also treated the misuse of trust assets allegations as a separate claim that is not protected. Therefore, the appellate court concluded that that cause of action does not arise from litigation in and of itself. Rather, it's a waste and misuse of trust assets, and affirmed. Thank you, and back to Beth.
Thank you, Jennifer. I have the privilege of introducing our speakers today, Anna Soliman and Bryan Kirk from Fiduciary Trust International. Anna is a senior trust and estates advisor with broad experience in estate planning and trust and estate administration, including preparing and reviewing estate and gift tax return and leading audits against the Internal Revenue Service. Anna was most recently attorney practicing in Los Angeles, where her responsibilities included crafting and preparing complex estate plans and business and succession plans for high net worth individuals. She also assisted her clients in trust and probate administrations and IRS audits. Earlier in her career, she worked with the IRS as an estate tax attorney, and before that as a DA in the Sacramento County DA's office. Bryan is responsible for overseeing financial and estate planning services at Fiduciary Trust. In addition, he regularly consults with clients across the country and internationally on an integration of their goals and circumstances into their financial and estate plans. Bryan has broad experience in multi-generational asset management and transfer planning. He works with gift, estate, generation skipping, and income tax planning, charitable giving, philanthropy, family education and governance, and liability and risk management. He serves as Chief Fiduciary Officer at Fiduciary Trust International and is a member of the Fiduciary Trust Management and Operating Committees. Before joining Fiduciary Trust, he was a partner at Otto Law Group in San Francisco. Anna and Bryan both bring a wealth of knowledge to us today, and we will turn it over to them for their presentation. Thank you both.
Thank you so much, Beth, and welcome, and thank you for attending today's presentation, Trust Reformation and Decanting Update. As Beth said, I'm Anna Soliman. I'm Trust Counsel and Managing Director of Fiduciary Trust, and I'm here with my colleague, Bryan Kirk. He's the Director of Estate and Financial Planning. Thank you so much for having us. Now, the next slide has some information and background for us in case you're curious. I also wanted to mention a few housekeeping items. So you should have a copy of this PowerPoint in your materials. And also, we're going to go through a lot of material today, but we should have time for a few questions at the end. We may even answer some along the way. But if we don't get to your question, we really do encourage you to contact us with your questions, email, call, write, however you want to communicate. Bryan and I are always happy to brainstorm with whatever questions you have. And here, this table of contents, this is just a little roadmap of our presentation. We'll go through the why, so the reasons why you would want to modify, reform, or decant a trust. Then we'll go through the how. During this section, we'll talk about California's newish decanting statute. We'll also go through the tax consequences of decanting. So we have some recent cases to share with you regarding this area of the law during this section too. And then we'll briefly go through what not to get wrong. We can go through the next slide, Bryan. And again, this slide just lists, we're going to go through the why, the how, tax consequences, some legal updates, and what not to get wrong. So Bryan, why don't you take it away from here?
Well, thank you, Anna, and thank you all for having us. Thank you, Beth, and the whole association here. When we talk about irrevocable trusts, there's a tendency to think, hey, it's irrevocable. You can't do anything with it. You can't change it. It's kind of written in stone. That is absolutely wrong, right? Just that a trust is irrevocable doesn't mean that it can't be amended in some ways. Even if it can't be amended, it doesn't mean that there still aren't options to modify that trust. And even if modification isn't an option for you, it doesn't mean that a trust can't be decanted. And that can happen in California now, like Anna mentioned, or it can happen elsewhere. So you really have at least 3 different things you need to work through anytime you sit down with an irrevocable trust and say, hey, this doesn't quite fit my situation. And there can be a number of reasons why that may be the case. So first off, so why would you ever want to modify, reform, or decant a trust? Well, we like to break that out into 2 sets of reasons. First, there's all your non-tax reasons for making a change to a trust. These can be administrative provisions. We work with a lot of trusts or have a lot of trusts come to us that are been around for several generations. That's a sort of certain recipe for having some boilerplate provisions in it, or sometimes lack of boilerplate provisions in it that you really want to change. It's also a good recipe for having changes in family circumstances. A classic one is you have somebody who has special needs and you have some concerns about upsetting their benefits by having them be a beneficiary. You may want to change it for that. You may want to change it because you want greater asset protection for your beneficiaries. A lot of times you'll have a trust that's being administered in California, or maybe it's being administered in New York, and it's subject to California law, Idaho law. And that's just kind of cumbersome because you don't want to have to call in your Idaho counsel every time you want to make a decision to trust. You'd like to have things match up. Maybe you're concerned about beneficiaries' rights to information. Often there just aren't provisions about what happens with trusteeship. And hopefully you're out in front of that and not sitting there with a vacancy. So you may want to address that. As you're addressing trustees, you may think about things like trust protectors or other advisors, maybe looking at dividing or consolidating trusts. There may just be straight up drafting errors or ambiguities that you spot, sort of right after the fact, and you got to make a change somehow. Could be investment reasons. It also may just be you want this trust to actually last a little bit longer. And a lot of these have tax reasons behind them, but you also sometimes have tax reasons that come up on their own. You could have a grantor trust that you wanted to be a non-grantor trust, and there isn't a straightforward way of doing that under the document. Or maybe you're going in the other direction, which is more likely to cause a challenge. You may want to give people powers of appointment. We'll talk about why you may want to do that or take them away. You could be looking at state income tax rules and be moving from one state to another, and then that gets into wanting to change governing law to match up. You may want to have, we've had a lot of new rules when it comes to retirement accounts, particularly in relationship to trusts. And so, even something that was drafted 5 years ago may be completely off base at this point in terms of how trusts are being trusts are handling IRO distributions. So that can be an issue. You also may have a trust that suddenly is taking ownership of an S corp, and you want to make sure you have provisions to allow that trust to either be an SBIT or QSST to own that S corporation and not disqualify the corporation. So lots of reasons why you may want to change a trust. And I'll give you an example, sort of a real life example here. You can tell me if you can spot the issue here. So we had spouses, blended marriage. Each of them had 2 children from a prior marriage. They also had 6 grandchildren sort of spread within those 4 children. And they were just going in doing their basic estate planning in 2006. It was a $10 million estate combined between the 2 of them. And they were trying to sort of figure out this generational balance. They wanted sort of the residue or the bulk of it to go to the children, but they wanted to do some specific gifts to their grandchildren, and not your sort of $10,000, $15,000 gifts, but some real substantial gifts. And they were working with their attorney, trying to figure out a way to do it. And what the attorney advised, which turned out maybe not to be great advice, was, hey, at that point, there's this thing called a GST tax exemption, and it's the amount that's designed to be able to skip generations and not be subject to tax. So she said, well, that's about $2 million. So why don't we use that for the basis for the grandchildren's gift? And the couple said, yeah, that sounds like a great idea. So what they provided for in their document was that they create this descendants trust for their grandchildren and be funded with their GST exemption amount on the death of the survivor. Now, what happened here is both spouses died in sort of close sequence to each other, and they died in 2018. They never updated this document. So hopefully there's some planners in the office, in the audience, or administrators who spotted the issue here. They basically disinherited their children. It wasn't what they intended, but it was very clearly what the document said to do. It said fund the descendants trust with this GST tax exemption, which at that point their estate hadn't grown really substantially. So it was going to be their entire estate was going to go into the trust for the grandchildren. Their children, who were supposed to get the residue when they drafted it $8 million, they're getting nothing. So we were able to go back into the court when we took this one over with all the consents from all the parties, and got the court to approve a modification so that the descendants trust was funded with what was the originally intended amount. That required a good deal of work, but it was possible, even though these trusts at that point were irrevocable. And so I'll skip over here our next example, and I'll turn it over to Anna to talk about how you go about making these changes.
Sure. So now that we've talked about the why, let's talk about the how. So a little background. California finally enacted a decanting statute in 2018. We were a little late to the game. And at that time, there were already a lot of states with different decanting statutes, as a lot of our planners here know. But before our decanting statute was enacted, if you wanted to change the terms of an irrevocable trust, you would have to change the situs of the trust to a state where you can decant, or you look at our trust modification statutes under the California Probate Code. Now, on this slide, I provided sections of the modification statutes, sections 15403, 15404, and 15409. I'm going to go a little bit out of order here. So for section 15404, Now, if all of the settlors of your trust are available and are willing to consent to the modification, and all of the beneficiaries are willing to consent, then you can modify the trust without court approval. Of course, very attractive option. It avoids the cost of having to file a petition. It saves time. I believe in LA County, if you file a petition today with the probate department, they're still setting hearings out, 4 to 6 months out. So if your settlors are available and all parties consent, probably the way to go. Many times, though, not all of our settlors are available, and a lot of the irrevocable trusts that we deal with are created as a result of the death of a settlor. So think your rev trust with mom and dad as settlors, and then they end up dying, and then we have the sub trust for the children and grandchildren are created. Those are usually the trusts that we want to modify. Those are the old trusts that have those funky provisions that we need to get fixed. And in those instances, we can't rely on section 15404. We have to rely on section 15403. And 15403 states that if all of the beneficiaries of an irrevocable trust consent, then they may petition the court for modification or termination of a trust. So again, if the settlor is unavailable, then the beneficiaries have to petition the court. I also included section 15409 here. This is the section that allows the court to modify the terms in cases where there are changes of circumstances. Bryan, if you can go to the next slide. So that was the trust modification statute under California law. Now let's discuss the specifics of the newish decanting statute. As I said, the statute was enacted in 2018. It's effective January 1st, 2019. And the decanting statute was mostly taken from the National Uniform Statute, and it applies to California trusts. Now, what's a California trust? So a California trust is a trust where the principal place of administration is in California, or the trust is governed by California law. Now, this also includes trusts that were moved to California. There are some exceptions, though, to the types of California trusts that you can decant. So, for example, trust solely for charitable purposes. Now, I'm not talking about a trust that has some sort of charitable component to it, maybe a charitable beneficiary. We're talking about solely purpose charitable trusts. Those are off the table. You cannot decant those trusts. And also trusts that sometimes it can include a clause that prohibits decanting. If it says you can't decant, you can't decant. And by the way, you can have a clause in a trust that can limit what you can change through decanting. So it doesn't straight up just ban decanting, but you can only limit what you can do. And if you do end up decanting a trust with those limitations like that, then the same limitations needs to be present in the new decanted trust. If you can go to the next slide, Bryan. Okay. So who exercises the decanting power? And the statute says that an authorized fiduciary exercises that power, which is defined as a trustee or other fiduciary that has discretion to distribute or direct a trustee to distribute part or all of the principal of the first trust to one or more current beneficiaries. So in most cases, in short, this is going to be your trustee. And the authorized fiduciary would exercise the decanting power by a signed writing, and the signed writing must include the identification of the first trust and second trust, the property that's going from the first trust to the second trust, and if you are keeping the first trust, any property remaining in the first trust, that also has to be included in that signed writing. California also has a notice requirement, meaning that the authorized fiduciary has to give 60 days notice to the individuals listed on this PowerPoint under section 19507. And on this list, we have our usual players, the ones that we normally give notice to, right? Our settlors, our trustees, beneficiaries, but very easy ones to miss. Someone who holds a power of appointment, someone who has the right to remove and replace a trustee. And of course, if a charity is involved, we have to notice our attorney general as well. You can go to the next slide. Okay, so what can we actually do with the California decanting statute? And the answer to that is that depends on the trustee provisions of the trust. Now, the statute discusses what's called an expanded distributive discretion trust versus a limited distributive discretion trust. Now, the definition of a limited distributive discretion is a discretionary power of distribution that's limited to an ascertainable standard. So as we know, this is going to be our HEMS trust, right? So health, education, maintenance, and support. And then the definition of the expanded distributive discretion is a discretionary power of distribution that's not limited to your ascertainable standards. So everything that's not your HEMS trust. So for the expanded, think about it as the trustee has more discretion and power over the distribution. And then for the limited one, the trustee has less discretion because they do have to abide by that HEMS or that ascertainable standard guideline. So what can we do with the expanded one? So again, these are our non-HEMS trusts. It makes sense. You have a lot more freedom than the limited one because you have more discretion and you don't need to stick to HEMS. So in general, you can change a lot of things, except you can't add a beneficiary who isn't already a beneficiary, but you can eliminate. You can't accelerate a presumptive remainder beneficiary's interest. You can't reduce or eliminate a vested interest, so an interest that's already vested. But a lot of what you can do is create or modify certain powers of appointments for current or remainder beneficiaries, and a lot of people sort of use this as a backdoor to get certain things done. Now for the limited distributive discretion trust, so again, these are our HEMS trust, you have to have substantially similar provisions in the second trust with the first trust. So, and the way that the statute sort of frames this is that there are no material changes in a beneficiary's beneficial interest. So the distributive provisions can't be more restrictive or expansive than the first trust. So let me give you a few examples here. So for example, you can't change the HEMS standard, right? So you can't take out health and education or maintenance and support. The HEMS standard has to be there. But you can add, for example, different definitions, right? So for health, you can say, hey, you include long-term health for education, you can include private school. So those are examples of what you can and can't do. Another example is you can't change the age of outright distribution from 25 to 30, right? So if the trust says everything goes outright to a beneficiary at 25, you can't change that age requirement, but you can change that distribution to a right to withdraw provision. So also in general, you can change a lot of administrative provisions. This goes for both the expanded and limited trust, but there are certain restrictions as it relates to trustee compensation, fiduciary liability, giving somebody the power to remove and replace a trustee, and even changing the grantor trust provisions of the trust. So if you are thinking about decanting a trust for one of these administrative provisions, make sure to take a look at the statute to see the special requirements there. And there are also special rules for special needs trust and charitable trust. If you recall, the purely charitable trust can't decant, but for a trust that has a charitable interest, charitable component to it, special rules for those. We don't have time to get into those specifics today, but you also need to make sure you look up the special rules for those types of trusts and also special needs trust. Okay. So there are a lot of states with some form of a decanting statute, but not all decanting statutes are the same. So for example, some states don't require notice. Some states allow you to decant an ascertainable standard trust to a fully discretionary trust. As I said earlier, we can't do that. Some states allow the removal of mandatory income. It really varies, and it's just a matter of state law. But if you do have a trust in a state and in a state that does not have a decanting statute, what are your other options? One of them is a non-judicial settlement agreement. And what this is pretty much a contract between the trustee and the beneficiaries that allow you to change the terms of the trust. There are some states that have specific statutes that allow for a non-judicial settlement agreement. So check to see if that state has that, allows for that. You could also appoint a new trustee, maybe that is residents in another state, and that way you change the situs of the trust, then that state's decanting statute can apply. And then you can also, and I don't really recommend this, use common law. You could try to say that, there's common law authority if there's no state statutes at all, but that's probably going to be your last resort. Next, I'm going to just quickly go through an example here. So this one is one of our sort of real life examples again. So let's say we have a parent who dies in Connecticut, that's your client, and is a beneficiary of a trust. And the trustees are a client's aunt who splits her time between California and Colorado. There's also maybe a New York corporate trustee. Now, after the client dies, the beneficiary of the trust is the client's son, and that son has special needs. However, there's a special power of appointment that may interfere with public assistance eligibility. And also there's a drafting error. There's no provision that says what happens to the trust when there is no surviving descendants. So there are a lot of layers here and reasons why you would want to decant the trust. Questions that should be going through your mind are, are we subjecting the trust unnecessarily to California tax because we do have this aunt who's a co-trustee? Is she considered a California resident? We do have to make sure that we provide for the client's son and make sure he can qualify for government assistance, and look beyond that and provide where the assets go to if the son passes away and doesn't have any issue. Bryan, I think this was a real life example that you worked on. What did you end up doing in this situation?
Yeah, it was, and it's interesting here because you do have multiple jurisdictions that need to work through, and we got to resist our temptation as California attorneys to think that California courts are, going to be our solution. Here, this was a Connecticut testamentary trust, so we did end up starting in Connecticut and working with their courts. But before, our goal there was actually to move it to a Delaware trustee, get rid of your corporate trustee in New York. That allowed the individual trustee to get comfortable with a different role for herself as an investment advisor, which is possible under Delaware law, which got us out of dealing with the sort of split of time between California and Colorado. Luckily, they were able to handle some of the California income tax concerns. And then once you're in a state like Delaware, you were able to use their laws to do a non-judicial settlement agreement, actually, to address the needs for special needs and get the sort of provisions right on the distributions when the trust was after the current beneficiaries passed away. So this is just a great example of, it can get really complicated, but if you start spotting these things that need cleanup, there are tools out there that you can use.
And I think I'm going to jump in and answer one of the questions that we have here. And the question is, who do you think needs to consent to a decanting under the California statute? And we'll talk about the tax consequences. I'm going to hold off on the consent part of it, but just know that the California statute does not require consent of the beneficiaries. It's within the trustee's discretion, right? But there's a question also as to, well, what happens to, the minors, unborn, etc. And in that case, remember, you don't think about, because you're not required to consent to the decanting, but you should think about the notice requirement. So if a beneficiary is a minor, they have to receive notice. And under California, what you would have to do is get a guardian ad litem. And what the California statute says is you can get a guardian ad litem by filing a petition to the court for the guardian ad litem without the underlying petition for the decanting. Usually for trust modifications, et cetera, to get a guardian ad litem appointed, you have to have an underlying petition. But in the decanting statute, you can just separately file a petition to get the gal appointed without having the decanting actually have a petition to approve the decanting. So, and we'll talk about, I guess, getting consents in general when we talk about the tax issues. Okay, so now the next topic that we'll discuss is the tax consequences of modifications and decanting. Bryan, if you can move to the next slide, we're going to talk just theory first. So when you reform or modify a trust, you're working with the same trust. So in theory, there really isn't a new trust. You're changing the terms of the old trust. So the way to think about it is that you really control the tax consequences based on what you modify. So of course, you have to be mindful of what you change. You're not going to modify a marital trust to include a non-spouse beneficiary or take away a spouse's mandatory income interest, right? But with decanting, on the other hand, the tax consequences aren't that straightforward. And the question is there a new trust? The statute talks about the first trust pouring assets into a second trust. Is it the same trust, but the terms have changed? It's a little trickier. So who can we ask for answers to this question? I'll tell you who we cannot ask, and that's the IRS. Decanting has been on the no private letter ruling since 2011. It's still there for 2023. So if we can't ask the IRS, Bryan, I'll ask you, can you go into a little bit more detail on decanting?
Yeah, Anna. So when you get into decanting and the tax consequences, there's two ways of looking at it. And again, we're talking theory here. And we'll get into how it gets applied practically. So the first way of thinking about it is to say, hey, there's no change here in terms of the trust. I just continued along with the same trust that I had. It's the concept that if I'm pouring from one trust to another, my first trust authorized it. I'm still working under the authorization of my initial trust. And so, I still just have one trust and I don't need a new taxpayer ID number. My GST tax status shouldn't change. Not making any new gifts to the trust. And there's no taxable event for income taxes, right? There's just, it's the same trust. But that's not always going to be your case. Sometimes you're going to be in a situation where what you've done, and you may be required to go this way, or you may opt to look at it this way, is that you've created a new trust, right? When you see statutes to refer to your original trust and your second trust or initial trust and second trust, those are different trusts. And now you've created a new trust, and we'll get into the details of that, but it may be required if you're actually decanting into what is a separate existing trust. Or you're decanting not all of the property into a new trust, right? So now you're going to have the old trust still be there. It's not going to go away. So now the new trust has to be its own thing. Or you're going to multiple trusts, right? So you can't have one trust continue as three trusts. That isn't quite possible. The math doesn't work. So you're most likely going to have three new trusts. Or you may be in a place where there's just substantive differences, or for convenience sake, you want to treat it as a fresh start with a brand new trust, brand new tax ID number. When you get into these situations, now you got to think a little bit more closely on things like, hey, has my GST tax status changed? Have I done something that may be construed as a gift? And a gift from whom? Do I have a taxable event for income tax purposes? And where this comes up is sort of what can seem like a kind of trivial question when it first gets asked, and I know it comes up for us a lot, but it gets right to the heart of it, which is, okay, I have this, quote, new trust. Do I need to get a new taxpayer ID number? If I'm getting a new taxpayer ID number, the IRS is going to look at it and say, well, looks like you got a new trust to me. I got a new number on my system. And so when are you going to go ahead and get that new TIN? When is it going to be necessary? Sometimes it's necessary as a matter of convenience. You may want to have that clean start with a new taxpayer ID number, a new tax filer. If you're going from a grantor trust to a non-grantor trust, especially if you're filing that grantor trust under the social security number of the grantor. Well, you're going to get a new TIN because you need one. You now have a new taxpayer you didn't have before. And that's often the best practice, even if that grantor trust may have had a TIN of its own and not been using the social security number of the grantor. Like I said, if you're decanting less than all of the trust property, if you're going to have portions of it still held under one TIN and portions of it under a new trust, most likely you're going to need a new taxpayer ID number for that new trust that's holding less than the portion that you poured over. And then again, if you're going to multiple trusts, well, now I got different trusts, and unless I'm kind of managing them as one, I'm going to have to get new taxpayer ID numbers for each of those trusts. And in most cases, they are not going to be the same as the taxpayer ID number as I had for the old trust. And when I do those steps, that means I have new taxpayers. The IRS is going to look at it, and they're going to look more closely at different aspects of it. And Anna, I'm going to make you start us off by looking at the GST tax status of a trust.
Yes, so GST and decanting and trust modification. So let's say the trust that you're modifying or decanting is a GST exempt trust. How do we make sure that we don't do anything that changes that status? Now, this can get complicated, but the IRS does provide some safe harbor rules under the regulations. Now, for grandfather's trust, so those are trusts that became irrevocable pre-1986, there are two safe harbor rules. One is the discretionary distribution safe harbor, and the second one is the trust modification safe harbor. So for the discretionary distribution safe harbor, the first requirement is that the trust became irrevocable and the terms of the trust or state law must have authorized the decanting. Now remember, this rule applies to grandfather trust rights or pre-1986 trusts. You might be asking me, but Anna, there weren't decanting statutes back in 1986, certainly not in California. How can I meet this first requirement if my trust does not specifically allow for decanting? I would say good point. And a lot of practitioners and commentators on this subject suggest that we can rely on common law to meet this requirement. And many states through common law did allow for decanting at that time. Also, for this particular requirement, we have to be sure that the distributions to the new trust does not require the consent of the beneficiary or the court. Okay, that's very important. And the new trust also does not violate the rule against perpetuities that apply in the first trust. So all those requirements are for the discretionary distribution safe harbor. Now, for the trust modification safe harbor, you have to make sure that there is no shift of beneficial interest to a lower generation. Makes sense, we're talking about GST, and that the regulations also require that the new trust does not extend the vesting of a beneficial interest. Now, these, in a nutshell, are the two safe harbor rules. They're explicit, they're in the regulations when it comes to grandfather trusts, but how about non-grandfather trusts? So post-1986 trusts, where in cases where either the grantor allocated their GST exemption to the trust or automatic allocation applied. Now, there aren't any Treasury regulations that specifically address this issue. There have been some rulings that do imply that these safe harbor rules should also apply to non-grandfather trusts. Now let's talk about gifting and decanting. Okay, so now let's talk about when is it possible for there to be a gift when we decant. Now, in order for there to be a gift, right, there has to be a transfer that happened. And in decanting, you're transferring assets from one trust to another trust. When can this be considered a gift? Now, in general, as long as the decanting power is 100% in the trustee's discretion, there should not be a gift. It becomes a little murky when beneficiaries are required to consent or consent voluntarily, or if the trustee is also a beneficiary. So this goes back to the question that we had as to whether beneficiaries should consent to the decanting. California law does not require that. And in fact, if the beneficiaries do consent, depending on the situation, the IRS may argue in this gray area that a gift could be implied in certain situations. We go to the next slide. So in terms of tax filings, as it relates to GST and gift tax, if the GST status does not change and you're in the safe harbor rules, then there's no filing requirement required. But for gift tax cases, again, shouldn't be a gift if you sort of fall under the California statute. But if you are in the gray area situation that we discussed, maybe consider filing a 709 to report the decanting of no value so that you can start the statute of limitations. So Bryan, why don't I hand it over to you and you can talk about the income tax consequences of decanting.
All right, so when we talk about income taxes with decanting, this is where it can get really technical, but I'll say in 90+% of the cases, you really don't need to think about it, right? Because there should be no income tax consequences associated from transferring assets from one trust to another trust via decanting. Where you need to be careful are in a handful of situations, right? First is sort of your classic cottage savings issue where if you have a beneficiary whose interest in the trust materially changes, you could have a situation where that could be taken as an income tax event. That's the classic, I walk into the grocery store with a bag full of peanuts and I walk out of it with a 6-pack of soda. My interest has changed. They're going to tell me that I had an income tax event happen somewhere inside that store. Need to give close attention because I walked in with a bag of peanuts and I walked out with peanut butter. It may not be the same case, but that's the concern when you're really changing your beneficiary's interests. You need to take close consideration there. The next couple are all related to each other. But if I have a trust and let's say it owns a piece of property and it has a mortgage on that property, so I have debt, I have a liability as trustee, and now I decant that property, including the liability, over to a second trust. Well, what's happened there? Well, I'm no longer on the hook for that liability. And if the situation aligns where I've been relieved of that liability, which is relief of debt, which we know can be considered income, and the basis in the property that I held was less than that relief of debt, then I could have an income event, right? I may need to recognize the gain that is the difference between the amount of income I have, the relief of debt, right, the liability I passed on, over my income tax basis in that property. The same type of transaction could occur if you have an interest in a partnership or limited liability company that has a so-called negative capital account. This is where somebody's pulled more money out of the company than they've put in. Often happens when the company is borrowing. And again, when I have that negative capital account, it's saying that I actually, in essence, owe money to this company. So when that LLC transfers over to the new trust, I'm getting relieved of that obligation. That could be income and very often can occur. It's a good test to say, a lot of times you're doing a decanting and part of the assets of these trusts that people set up are LLCs or partnerships, and you think, hey, I just need to do an assignment and it's all done. No, put on your tax hat for a moment. Make sure you get the last K1s, understand what the capital account is for the trust in the entity. In most cases, it's going to be positive, won't be a concern, but you may have the situation where that capital account is down low or it's negative, and you need to be attentive and make sure everybody understands what may happen from income tax status here. Same type of thing can happen maybe when you don't even have sort of your one trust to another trust, when you're just making a change or modification from a grantor trust to a non-grantor trust, because even though the trust isn't changing, you're changing the taxpayer, which IRS can look at and say, hey, you need to recognize gain because you have one of these sort of negative basis assets. The other thing you need to think about from an income tax perspective is that, and this goes back to my initial point on, do you have a new trust? Do you get a new TIN for that trust? Because if you are in that situation where you have a new taxpayer, you got to consider, well, how am I handling all my tax attributes of my first trust as I move to the second trust? Is this a DNI event? Am I just making a distribution from my first trust to my second trust, in which case I'm going to be doing some shifting of income based on a distribution? Or am I treating it as if there's a continuation? And we'll talk about that in a second. Also, just know if you're dealing with foreign trusts here, moving from domestic to foreign trust, you may have gain recognition under 684. I'm not going to get into that. I'll kind of repeat those things, just going through the reporting requirements, just so you get a second shot at it. So we have a number of times where you're not going to do any new income tax reporting. If you're just treating it as a continuation of the initial trust, you're just going to continue to file income taxes under that same taxpayer ID number. If you are going to change from a grantor to non-grantor trust, probably aren't going to have any special tax reporting, but you are going to start filing a new tax return, and you got to be attentive for those negative basis assets. The IRS has ruled that when you move from one non-grantor trust to another non-grantor trust, there is an option to ignore it for income tax purposes and not have to do the shifting with DNI between the first and second trust if your terms are substantially the same. If you've done some major shifting, you got to reconsider there. Now, what are your reporting situations where you're going to have to involve the accountants who should be involved in any case, but really have them do some work? If you're not going to just be shifting the tax attributes from one trust to another, if you're going to be treating it as a distribution of trust assets from one trust to another, you want to have the accountants do the math, kind of do a pro forma 1041, so that you understand how that income is going to shift to that new trust, who's going to pay what taxes, how's that going to impact estimated taxes. All of those steps you want to go through before you do your decanting, and also think through exactly how they're going to shift some things like net operating losses, carryover loss carryovers, how other tax attributes that may be present in the first trust are going to happen on the second trust. You need to think through all those things when you're going through decanting if you're not going to treat it as a continuation. And again, think about your gain recognition events. If you get into those situations where you have those negative basis assets, typically what's going to happen with a grantor trust, the grantor is going to be the one who's going to have to report that gain for the relief of debt or for that negative capital count. If you have a non-grantor trust, they're going to be the one that's going to have to report that gain. And then if you had a material change in the beneficial interest, one of those cottage savings situations, then it's actually your beneficiary who's going to be doing that reporting on their income tax returns. I think now we're going to turn into some recent cases and rulings. I'm going to keep going with these. The first one here is the Dunningham case. This is a California case from 2019. This gets into what Anna was talking about with your 15409 modifications of trust for changes of circumstances. And really where you need to look at things, not just from a client perspective on what's changed, but put on your attorney hat when you do it. So back pattern here, pretty straightforward. You had a couple, Therese and Joseph. They both had children from prior marriage. They created a joint revocable trust, pretty standard ABC trust planning, provided that when the second spouse passed away, they'd all be consolidated, and then they'd be distributed among their respective children. This plan was what was in effect. Joseph passed away. Also, 2 of Therese's 4 children passed away. She also had a falling out with some of the grandchildren. And so what does she do? She says, hey, things have changed. Like, this is a pretty drastically different life circumstance than when I drafted this revocable trust. So she goes and petitions under section 15409 to change the distribution provisions to actually substitute her children for some of the gifts that were going to go for her grandchildren. What does the court say here? It says, well, you got the statute right. You're coming in here under the right statute. You're the settlor. You can file this petition. But here's the thing. The death of your spouse, death of your children, the falling out you've had from your grandchildren, those are not changed circumstances that are going to impair the accomplishment of the trust. And I find this just really interesting if you think about it, like trying to deliver that message to the client, especially after they lost in the court, when it really probably was something that needed to get delivered to them up front here, rather than let the sort of client, drive the case here, to say, hey, put on your attorney cap and look at it from a planning perspective. What are you doing as an estate planner when you draft these trusts? Well, you're working through, what do you want to have happen if your spouse dies? What do you want to have happen if your children die? And just the fact that you have a falling out with someone doesn't stop those provisions from being true. If I provided for somebody in my will, and then when I die, I happen not to be on great terms with them, we all know that gift is still there. I should have amended that trust. So the court here is doing something that probably sounded totally counterintuitive, flatly wrong to the client. But as attorneys, we should recognize it as being, pretty true that, this is actually what you're doing when you do an estate planning documents. And if things turn out wrong, well, that may be a problem for the estate planning attorney or in the client, but it's not something that's going to give you a basis to modify the trust. Other case here, this is one out of New Hampshire, but it's sort of a seminal case when it comes to decanting. Lots of decanting happened here. David Sr. created 2 irrevocable trusts. He did decantings to get to those irrevocable trusts. The trusts were for the benefit of his ex-spouse, children, his stepchildren. They had exactly what you would want in terms of provisions to do decantings. Broad distribution provisions actually explicitly called out the right to do a decanting. So he did them. He did 3 rounds of decanting. He did in 2010, 2012, 2013. And he just kept on moving away people he didn't like, right? So he got rid of the stepchild Barry, then he got rid of the other stepchild, got rid of his son out of the documents, eventually got rid of the ex-wife too. They were all moved out of there. And of course, someone gets upset and says, hey, that trustee violated their duties to remove those folks as beneficiaries via those decantings. And that may seem like, hey, that seems pretty right here, that trustees have duties of impartiality, and if the trustees doing decanting to get rid of beneficiaries, that's a problem. But the court actually does something or says something that's a little more subtle than that. And it gets into what's really key, which is the process in which you go about these decantings. And they say, hey, the fact that it says we have a duty of impartiality didn't mean you had to treat people equally. It just means you had to treat people equitably in light of the purposes of the trust. We all know there can be pot trusts that say give it to 1 of 3 beneficiaries, and it's totally possible one of those beneficiaries would get nothing out of that over time. And so it's not a per se violation of the trust to eliminate a beneficiary. What is a violation of the trust is just not to even consider those other beneficiaries' rights, not even consider the purposes of the trust when they drafted to include those beneficiaries. The trustee may have been able to do this if they actually showed that they gave some attention to their duty of impartiality, but the fact that they didn't even think about these other beneficiaries, that's it, they violated their duty of impartiality. There's a lot of private letter rulings that you'll see issued around modifications of trusts. Even though what Anna said is totally true, they're not going to review, they're not going to give you rulings on the specific consequences of a decanting, but you'll see a lot of times you'll end up with court orders that have come out of situations that involve decanting. And so what the court is asked to do is to confirm the tax consequences of those court orders. So I wouldn't dismiss the relevance of private letter rulings. It's just that it's not going to be specific to the decanting itself. And then we have a handful of cases here. I know we're getting up on time. So Anna, maybe if you took your top hit off this list, and then I maybe take one myself.
Sure. So why don't I'll go over the McGregor case. So this case dealt with a non-judicial settlement agreement. It's in Nebraska, but I just find this case very interesting. And it modified a spendthrift trust to distribute property outright. So you have Mr. and Mrs. McGregor, they create revocable trusts. When Mr. McGregor died, a family trust was created for the primary benefit of his wife, Mrs. McGregor. And then after her death, that family trust would then be divided into 2 separate trusts for their 2 children, Alan and Deborah. The trust for Alan and Deborah are a lifetime trust. Alan and Deborah, they don't like this. They want their assets to go outright to them instead of in trust. So they go to mom and say, hey, mom, can we get this outright instead of trust, instead of being held in trust for our lives? Now they all get together and they enter into this non-judicial settlement agreement to distribute the family trust outright to them rather than in trust. And at some point, mom got mad. Mrs. McGregor changed her mind and said, I want to cancel this agreement. Alan then went to court to approve the non-judicial settlement agreement, pretty much saying, Mom, you can't take this back. And surprisingly, the court held in favor of Mom, Mrs. McGregor, and said that the agreement is invalidated on the basis that it violated the material purpose of the trust. There were also some issues about the agreement not involving any interested persons, the issue or so of Alan and Deborah. And because of that, the court also said that the non-judicial settlement agreement was not valid. Bryan, do you have one to go over, or do you want to go over a question that we have here?
Why don't we take the question here that we have, and then we'll wrap up.
Great. So the question is it possible to move a trust to a state with a more flexible law and then make your changes not allowed in California? This happens actually quite often. You use the California decanting statute. We did this some other time, right? Or maybe a few months ago, where we appointed our Delaware office to be the trustee and also changed the provisions so that Delaware law applied, and then made whatever changes we needed to do in Delaware. So very common. Just make sure that when you do decant and change the law to the other state's law, that you're not still have a California trustee, right? Because a lot of times for tax purposes, you want the trustee not in California so that you don't have to pay California tax.
Yeah. And so, yeah, and so I'll just sort of wrap it up. So what do you want to not get wrong when you do a modification, reformation, or decanting of a trust? Don't lose sight of your fiduciary duties here. That's always, figure out why the client wants to do it, what's driving it, what the solution should be. But then I always say, then start fresh thinking through your fiduciary duties, because it's the trustee who in many cases is going to be the one to act specifically with the decanting. You want to make sure that that trustee feels comfortable doing that. Part of that is to walk through the process. Don't lose sight of it. Even if it has to go through a court, the court usually isn't the end of the process. It's sort of like the big chunky thing in the middle. They're speaking of process, think through your tax implications, understand, use the little checklists, go, okay, am I getting a new TIN? What do I think is going to happen for GST? What do I think is going to happen for gift tax? What do I think is going to happen for income tax? Look at it as an attorney, look at it as an advisor, look at it as a CPA, work together as a team to make sure everybody's clear on what you think the implications are. That hopefully can set up your reporting to be straightforward. You're just doing what you think you can do, but think through the reporting, because sometimes that brings out issues that you otherwise missed. Don't lose sight of titling of assets. If you're going to do a decanting, the whole idea is you're transferring assets from one trust to another. Doesn't go so well when the title of those assets still says your initial trust. And part of that, make sure you update all the parties. If there's trustees involved, we've seen it where a trustee still thinks they're holding on to something when they're not. If there's trust protectors involved, they may still think they have the role when they're out of the role. If there's somebody new, they may not realize that they're in the game now. Make sure that all those parties who are connected to a trust, certainly with some of the more modern trusts, are aware of the changes that are being made. That's a great way of then making sure that all the other items on this list are taken care of, seeing it from different angles. And so that's really it. Hopefully you guys have done the things we've set out to do, understand why you may make changes to a trust, how you're going to do it, tax consequences, and some things to avoid along the way. Thank you.
Thank you, Bryan and Anna. We really appreciate it. This was a great and very informative presentation. I am confident that our members will have gotten a lot out of it. And I'm just going to reiterate their generous offer that if anybody has any questions that come up after this, please feel free to reach out to them directly. Thank you so much for your time. And we look forward to seeing everybody next month. Have a great day.